Okay, Mr. Tinker, you're up.
May it please the court. Good morning, Mark Tinker on behalf of John Cassidy. I'd like to reserve 5 minutes for rebuttal. And in stark contrast to what you just heard, I don't know that there's any way that I could talk about all the issues we've raised in the 20 minutes that we have. So what I'd like to do today is focus on 3 of them. For the remainder, I'd rely on the briefs and also rely on them for their cumulative effect.
Sure.
The 3 that I'd like to talk about first is the issue involving all the references to alcohol, to intoxication, to drunk driving. I focus on that because it was pervasive. It infected the entire trial from voir dire all the way through, well, past closings into the jury's deliberations. The jury even asked questions about the issues. So I think that that's a primary key for this argument. The second issue is the evidence of past medical bills that had been written off. There were a couple $100,000 worth in this case. That's an issue that was debated quite a bit in the trial court and of particular interest to the parties here, as a unique situation. It was a debate that revolved around Jorg versus State Farm, which the court's familiar with. It was of interest because we had personal involvement in it. I actually was State Farm's counsel in that case, and Mr. Reichenbach's trial counsel here, Damian Millard, was Jorg's counsel. So we both knew the case well. We debated it in front of the trial judge. While briefing was going on in this case, this court decided Dial versus Colusa Palms. That decision tells us that the trial court got it wrong in this case. So that's the second issue that I'd like to talk about and explain why that's reversible error, or I think more accurately, under Special versus West Boca, why Reichenbach has now established that there's no reasonable possibility that that error did not contribute to the verdict in this case. And then the third issue is the denied discovery into the reasonable value of medical bills, the reasonable cost of medical expenses for all of Mr. Reichenbach's past medical bills. That's an issue that was actually attempted to be raised to this court. There's a petition for writ of certiorari that was filed during pretrial proceedings. As it turned out, the petition was still pending. As this case went to trial, this court eventually dismissed the petition as moot because a verdict had been returned before anything had occurred, and that was a discovery petition, so the court found it moot. But the issue is still there, and we believe it's still harmful, and it was actually is something that was raised and brought up at trial to show exactly where that information would have been used and why it was harmful. So I think with that roadmap, as far as the 3 issues, unless of course if the court steers me elsewhere, I'm happy to talk about any of them. But with that roadmap, start with the intoxication references. This is obviously it's an interesting and unique case. You have a situation where there are 3 men, 3 grown men, 2 of them retired, 1 semi-retired, driving in a car. All 3 of them agree who was driving. The driver, Mr. Logan, Greg Logan, says, "It's my car. I don't let any non-family members drive my car. I was driving it and I caused the accident." He said, "I feel awful about it. I can't get that sound out of my head." He actually cried on the stand talking about it. It was, of course, labeled alligator tears and was used against him. But he freely admitted, I didn't see him. I caused the accident. It was my fault. I was driving my car. A couple of eyewitnesses said they thought they saw Mr. Cassidy get out of the driver's seat. So that's why we're here. That's why this ended up at trial the way that it did. But that's the situation that we have, is all 3 of them say Mr. Logan was driving. He's the one that caused the accident. And in pretrial proceedings, there was obviously the accident occurred. Police arrived at the scene. They investigated. There was an arrest made. Actually, they arrested Mr. Cassidy because the witnesses told the police at the scene that they thought they saw Mr. Cassidy driving. He had just come from the dinner where he said he'd had a couple of drinks at the birthday party dinner for the retirement party for this teacher that was retiring. He said he'd had a couple of drinks. He had alcohol odor on his breath. He refused a breathalyzer because he said, "I wasn't driving. Why should I give a breathalyzer?" So he was arrested because the police were told that he was driving and he refused a breathalyzer. Mr. Logan said, "I was driving." He was arrested too for obstruction of justice because the police said, "Well, the witnesses say you weren't. So, you're lying to us." So that occurred. As it turns out, all of the charges were dropped. The police actually did polygraphs on both of them. They both passed. They had them independently reviewed, said no signs of deception. These 2 gentlemen are not showing any signs that they're deceiving us when they say Mr. Logan was driving the car. And there was no evidence of intoxication. The DUI charge was dropped. every charge, everything that was filed was dropped. So all pre-trial, there was a motion in limine to exclude any references to supposed intoxication. It's not relevant to anything that was being tried. The issues being tried are who was driving the car, if it was Mr. Cassidy, how much are the damages? Those are the only things being tried. So
But
any,
Mr. Tinker, you're not suggesting that to exclude all evidence of alcohol, because certainly the alcohol was relevant to the motive to lie. I mean, that was a really big part in proving their case that Mr. Cassidy was driving.
correct, and that's what, and I agree with you, and that's what the trial judge ruled pre-trial. She said, I'm not going to allow intoxication. We're not going to talk about drunk driving or intoxication. I will allow you to talk about that he had a few glasses of wine at dinner so that he knew he had been drinking, and that is, as you say, that's the alleged motive to lie, is that he knew he'd had a couple glasses of wine at dinner. That's not what happened at trial. At trial, I think I labeled 13 different motions for mistrial, more than that, a number of objections that occurred. It turned into intoxication. He's not right in the head. He's driving while impaired. This is what happens when you drink and drive. Like I said, it started from voir dire, where the prospective jurors were all saying, we're here talking about drunk driving. I have no tolerance for drunk driving. Went into opening statement. This is what happens when you drink and drive and cut in front of somebody. The issues as far as with the two police officers, I think was the most egregious of the issues, is we already have people establishing exactly what you said, Judge. You have the admission that, yes, I drank at dinner. The very first witness they called at trial was an eyewitness, Miss Baglini. She said, I was standing right next to him. I smelled alcohol in his breath. I could tell you that I could tell that Mr. Cassidy had been drinking just from standing there. They had that in trial. So then they bring in Officer Flint and have the first police officer arriving on the scene tell the jury that he got there, he investigated, he was told Cassidy is driving. He went over and interviewed Cassidy. He smelled alcohol on him. He thought his eyes looked bloodshot, red, glassy, watery. And then he
Was there any pretrial motion as to that officer's testimony?
There were multiple, as far as pre-trial.
No, what was the ruling of the court going into trial as to that officer's testimony and excluding any of that evidence?
Going into trial, it got confused. The judge originally said that she was going to allow him to testify over objection. After opening statement, the judge thought that he was actually the DUI officer, so she reversed course, and then she was informed that he wasn't the DUI officer, Arthur was, so then she allowed it again. But there was extensive argument the evening before his testimony. There was argument to keep him out completely because it would be prejudicial to have him get up there and say, I was the first on the scene. I'm an investigating officer. I interviewed him. I thought he was the driver. I thought he smelled of alcohol. I thought he looked intoxicated, and then just stop right there. Because what is the jury going to think? He got a DUI. We're not, everybody's hiding that from the jury. He said, then I did that part of the investigation. I turned it over to Trooper Arthur. The evidence is extremely, Trooper Arthur should have been stricken from the witness list altogether. There were multiple hearings on that. There were admissions by Reichenbach's counsel saying, I'm not going to call Arthur. I know I can't. That wouldn't be allowed. I'm not going to call him. The judge said he's stricken. He's off the list. That morning, there was the argument about Flint again, and it was reiterated, nobody's going to call Arthur. We can't bring him in here. As soon as Flint is done testifying, Reichenbach's counsel stands up and calls Trooper Arthur. Not only does he announce calling him, forcing Cassidy to get up and go to the bench and have him, have the judge exclude him. So now the jury knows Cassidy's hiding whatever Trooper Arthur has to say. Trooper Arthur was waiting in the hallway in uniform, ready to testify. He was stricken from the witness list. He had no business being in the building. He was there. He comes in. The jury could see him. He's in the doorway. The judge has to tell the marshal to take him back out. So the jury sees all of this and knows, here we are with a police officer who arrives at the scene, says Cassidy's driving, thinks he looks impaired, turns it over to Arthur. Reichenbach wants to tell the jury what Arthur has to say. Cassidy's hiding it. What does the jury ask immediately as soon as it goes out for deliberations? Were there breathalyzer results? Was anybody arrested? Who got the tickets? These are issues that have nothing to do with who was driving the car. The jury wanted to know, was there drunk driving? That's what they were asking, and that's what was shown to the jury as far as the charade that happened with Trooper Arthur. And of course, the reality of the situation, that if that wasn't prejudicial enough, the reality is if we ask Trooper Arthur, put him on the stand, what happened, he's going to say they both passed breathalyzer results. All the charges were dropped because the state decided Cassidy wasn't the driver. That's what it says on the letter that dismissed, that Trooper Arthur wrote. He said, please dismiss my citations. Reason, not the driver. So that's the reality of what Arthur would have said. But now we have a situation where the jury thinks that Cassidy is hiding the fact that he got a DUI for this. And that was, like I said, it was pervasive throughout the entire trial, went into closing arguments. And I know, I've raised the issues in closing as far as, it's its own separate issue, but at the same time, it also goes into, it meshes into all of the other issues. Because when the court is considering harm, or, whether there's harmless error, whether there's harmful reversible error, it of course can consider the combination of unpreserved and preserved errors. So if the closing standing alone, if I had to go travel under the Murphy standard, that would probably be quite an uphill battle. But if you're looking at in the context of, we had all of these violations of the motions in limine about intoxication. We had the violation of Trooper Arthur. We had the violation of the dinner receipt with the bottles of wine on it, where it was, the judge had made an express ruling, you have to redact the number of bottles of wine. And counsel instead stands up there and reads it to Mr. Cassidy while he's on the stand. It says, isn't it true that it's 4 bottles of wine? But then says, well, I didn't violate the motion in limine because the motion in limine was as to the physical receipt. That's nonsensical to say, are you going to redact the physical receipt, but you're allowed to stand there and just read it to the jury. So all of these things occurred all throughout the trial. And then the closing arguments, whether they're, under the Murphy standard or not, they come into play as far as the harm that this caused. And again, the jury's questions during deliberations show that's what they were concerned with. The very first thing they did, they were hardly out. I believe the record shows it was within 20 minutes, within a half an hour, 20 some minutes, that they're asking breathalyzers, arrests, citations. That's what they want to know about, not who was driving the car.
Well, let me ask you this, Mr. Tinker. The plaintiff's theory about why the jury should believe the 3 eyewitnesses who said Mr. Cassidy was the driver was that he had been drinking and was concerned that he would be charged, with an alcohol-related offense, and therefore swapped responsibility with the other fellow, correct?
Correct.
So isn't it not logical that the jury would ask those questions because they never received any evidence in that regard? I mean, you can say, well, they talked about alcohol, but that was their theory, was the alcohol.
And the ruling was the pretrial
The
ruling.
reason was that you can't talk about alcohol.
The ruling was you cannot say intoxication. The ruling specific can't say intoxication, and
Right.
you can say had a few glasses of wine was the direct quote.
But that from the defense plaintiff's perspective, a few glasses of wine was not accurate. That would be, lying to the jury, would it not? Misleading the jury.
From the plaintiff's perspective, but the ruling was intoxication is not
So
allowed.
come back. That was the ruling. But, how long was this trial?
It lasted about 2.5 weeks, but there was a week.
So you're suggesting that we should reverse a verdict after a 2.5 week trial based solely on the violation of the judge's pre-trial ruling. But then my concern has more to do, because, whatever the judge ruled pre-trial, she allowed this. So my concern has more to do with whether it was relevant versus the prejudice.
I understand absolutely what you're
When
saying.
we're talking about reversing the judgment based on a 2.5 week jury trial.
And I think it's not just the one pretrial ruling as far as, are we going to talk about it had he been drinking? It is the culmination of allowing, it went far beyond the intoxication. It went into drunk driving questioning during voir dire, even where we're trying to strike the panel.
I get that. But I'm telling you, it doesn't bother me if they violated the pretrial ruling. Because the pretrial ruling, because if they were held strictly to that, and then your side, quote, won this case, they might be up here arguing that the pretrial ruling was incorrect. But whatever the pretrial ruling was, the judge allowed it. And
Yeah.
that's where the rubber is hitting the road in terms of whether this verdict could stand or not, I think.
Correct. And I get what you're saying. If the judge ruled pretrial and she started morphing her ruling as the case went on, I understand that. But
Yeah.
this was entirely too far. This was egregious to allow, again, where the judge is emphatic to say Trooper Arthur is not going to testify, strike him from the witness list. He's not going to be here. We have Reichenbach's counsel saying, I'm not calling him. I know I'm not going to call him. That'd be a mistrial. I'm not calling him. He's in the courtroom in uniform, ready to testify immediately after Flint.
Okay, so what's the prejudice as to that? Because some of the other arguments that you're making, a trial judge, even though there's a pretrial ruling, is entitled to change their mind as the evidence develops, which is clearly what happened here. So what's the prejudice as to that? Just solely their presence in the courtroom?
The prejudice is exactly, and it's the, I think, let me get.
Was there
And I will
something
tell you,
tied
and I
from
will-
my, oh, sorry.
Well, I was going to say, you're right at your 5 minutes, Mr. Tinker. So
Okay.
I won't,
Wait,
I won't penalize you for this, but
The prejudice is that it's what is implied to the jury that Cassidy is the one hiding because he wasn't supposed to be there. If the trooper, if Flint testifies, I smelled alcohol, I did the investigation, I turn it over to Trooper Arthur. Trooper Arthur stands up, Cassidy sends him away. The jury thinks what now? That Cassidy did get a DUI. We know that's not true, but we can't tell anybody that. The judge had already ruled we can't tell anybody that. That's the prejudice. And the jury is asking about it after and during deliberations. That's what they want to know. And we know the answer, but nobody can tell them. But the implication was yes, because Cassidy stood up and objected. Cassidy is the one that told the judge to have the bailiff take him out of the room. That's the prejudice.
okay. So now I'm going to start counting the 5 minutes against you.
All right, and I'll just very quickly, I think I have to touch on this because it's the written off medical expenses because this did, the law did basically crystallize for us during briefing in this case with this court's Dial versus Calusa Palms decision. Obviously, in this case, we know there were about a couple $100,000 worth of medical bills that Mr. Reichenbach put into evidence, said, yes, those are my damages. The jury awarded them all. We know those weren't his damages. We know they were paid by Medicare, Medicaid. They were written off. They cannot be balance billed. Under cooperative leasing versus Johnson, this court said those are not admissible. They're not damages. It was the judge allowed it in under what her interpretation of Jorg versus State Farm and what the Supreme Court ruled there. This court is again now clarified Jorg relates to future benefits because future benefits, governmental benefits are uncertain. It's speculative. We don't know if the person's going to continue to receive those. That's not the case with past. We know they already received them. We know they can't be balance billed. We know there's no right to subrogation. We know that's never going to be a damage to the plaintiff. That's not evidence. So the court in Dial has established that now. I will say, I don't know if you've been following, but I just checked the docket on Monday. The Supreme Court did accept jurisdiction over the certified question this court posed. So that is still pending with that court. But as of now, this court, I believe, is bound by Dial under the prior panel rule. If Reichenbach would like to make this a pipeline case on that issue, they can certainly do that. But the issue does exist here. They have not established that there's no reasonable possibility it couldn't have contributed to the verdict under Special versus West Boca. I think the arguments that I've set forth in the brief show why they can't do that. And I know I'm very short on time. So at this point, I would just reserve the rest. Thank you.
Yeah, right at 3 minutes. Okay, go.
Good morning, Your
How
Honor. Tom Sider with Granite Humphreys and Berman for Johnny Reichenbach. I'll touch on the two issues that Mr. Tinker addressed today. Before I do that, I do just want to note, for all of the rulings challenged on appeal, we're dealing with an abuse of discretion standard. And in this case, Judge Rule, she did not abuse her discretion. She called balls and strikes, and it certainly cannot be said that no reasonable judge would have ruled as she did. And I think that abuse of discretion standard is especially important when we're looking at the evidence of Mr. Cassidy's drinking. As you noted, Judge Smith, this was vitally important evidence for us because it spoke to credibility. We had 3 eyewitnesses saying one thing, and then we had Mr. Cassidy and his friends saying another. And so it was vitally important that we be able to explain to the jury why it is that he would have a motive to lie. And this court's precedent says that not only is motive to lie evidence admissible, it's error to exclude it. And so in this case, it was incredibly important that we put it in, but the trial court did everything that she could to sort of minimize the prejudicial impact and to narrow the scope of this evidence so that it would cause Mr. Cassidy the least amount of prejudice. I do want to note, we did not violate any of the trial court's pretrial rulings. What happened pretrial is the trial court ruled that we were allowed to present some evidence of Mr. Cassidy's drinking. And then the parties agreed that we were going to be able to present physical observations about Mr. Cassidy. There was no official ruling on that issue. Judge Smith, you had asked about that I'm aware of, but the parties seemingly understood that there was going to be testimony about the way Mr. Cassidy looked immediately after the accident. And then we get to trial, we give our opening statement, and we say that Officer Flint is going to come in front of the jury and is going to provide testimony about those observations. We get an objection from Mr. Cassidy. The trial court considers the matter further. There's some concern expressed by the trial court that are we going to hear the words DUI? Is there going to be any evidence about a DUI investigation? Ultimately, the trial court is convinced that there isn't going to be anything like that. We're just going to do physical observations. And then that is exactly what happens. I did hear Mr. Tinker say that Officer Flint said Mr. Cassidy looked intoxicated. He did not say that. What he said is he had bloodshot eyes, he smelled of alcohol, and there was testimony that he was leaning against the car, and that's it. So there was no ultimate opinion on intoxication. We didn't violate the trial court's pretrial rulings. And as far as the Officer Flint issue goes, some background on that I think would probably be helpful. With Officer Flint, before trial, both parties wanted to keep Officer Flint out for different, I'm sorry, I'm saying Officer Flint, I mean Trooper Arthur. Trooper Arthur out for different reasons. Trooper Arthur initially charged Mr. Cassidy with a DUI, and then he later wrote a letter saying, we're gonna have to drop the charges. So we didn't want the letter in, and Mr. Cassidy didn't want the charges in. The parties agreed, and we never were going to call Trooper Arthur for that purpose. And so that explains the trial court's statements about, well, Trooper Arthur can't come in to say that. The reason that trial counsel was calling him when he was is to offer basic background information about the accident. He wanted him to authenticate some photographs, say where the cars were positioned after the accident, things like that. He originally was going to call a different officer. It was a mix-up and it was an honest mistake. But from the jury's perspective, all they saw was a police officer momentarily walk into the courtroom and then leave. There was not actually any reference, but as far as I'm concerned, as far as I remember, Officer Flint didn't mention Trooper Arthur, and the trial court significantly said the jury's not going to think anything of his momentary presence in the courtroom, especially in a case where the jury is well aware that the police were involved, that police were all over the scene of the accident, and Officer Flint had already testified. So there's no a prejudice there, and the trial court's finding in that regard should be deferred to on appeal. Unless this court has any further questions on this issue, I will briefly touch on the past medical expenses. The full amount was boarded at trial. That issue was waived. And so pre-trial, we had this discovery dispute where Jorg was discussed kind of at length. And then there was another motion that was filed by Mr. Cassidy. And the motion said, well, Mr. Reichenbach should not be allowed to board his full medicals at trial. And what we argued was, Your Honor, you've already ruled on this. That's what Jorg is about. It's about collateral sources. And so your previous rulings about prejudice, they should apply with equal force here as to the full medical bills going in as to past medical expenses. Mr. Tinker argued this issue below, and he very ably argued to the trial court that, well, no, this is different. There's this cooperative leasing case from the second DCA, and it treats past Medicare and Medicaid benefits differently. Mr. Reichenbach is not on Medicare or Medicaid, but he did have some of his bills written off by sort of peripherally related in a way to Medicaid benefits. But all that to be said, what happened was Mr. Tinker argued you should instead grant our motion. You shouldn't let the full bills to come in. The trial court deferred ruling. The trial court said, all right, well, I'm not sure. I'm gonna look at the motions and the cases. So I defer. That's what the trial court said pre-trial. The trial court entered an order saying this matter is deferred until trial. And then at trial, when we went to introduce our full medical bills, not only did Mr. Cassidy not object, he affirmatively states on the record, no objection, Your Honor. So we don't have a definitive ruling here. The law is crystal clear that when a trial court defers pre-trial, it is incumbent on the objecting party to renew an objection in order to preserve the issue for appeal, and we don't have anything like that here. And so our position is that this issue can be resolved purely on waiver grounds, and if not, the lack of preservation, then because the error is inherently harmless, because ultimately, whatever medical expenses were admitted at trial, they were reduced post-trial to account for any set-offs. So if this court doesn't have any further questions, we would ask that this court affirm the trial court's final judgment in all respects. Thank you.
Thank you, Mr. Sider. Mr. Tinker.
Just quickly, there was a statement made, we did not violate any motions in limine. And I know, Judge Northcutt, your position as far as, whether the order is morphed during trial, but, the order and the judge's rulings consistently throughout, and I believe Mr. Sider even just conceded it wasn't to say intoxication. We couldn't get that far. But the issues that were made were in direct violation of that. You have someone saying, these people were out drinking, one had too much and he happened to be the guy driving. Now that doesn't use the word intoxication, but to say somebody was drinking too much and driving, that's the same thing. You were drinking and driving, drinking while driving, driving intoxicated. I mean, you use whatever turn of phrase you want. That is what occurred. The issue with Trooper Arthur, the issue, the comment was made, well, he was maybe there for another purpose. He was there to authenticate some photos. He was stricken from the witness list. The judge said, he's not going to be here, take him off the list. When he wasn't taken off the list, there was a renewed hearing to say, he's still there, judge, make them take him off the list. The judge said, he's stricken, get him off the list. There's no reason for him to be in the building authenticating anything or doing anything. And then as far as whether the jury thought anything of it, the deliberation question asked specifically for FHP, Florida Highway Patrol. He's the only person in the entire trial they heard that was FHP. They heard it during Sergeant Flint testifying. That's who they were asking for. That person that got sent away, that's who the jury asked about during their deliberations. The third thing, and I think this is kind of to get both of them together, at the beginning, Mr. Sider said, everything you're talking about today is under abuse of discretion. The one issue as far as the written off medical bills, that is an evidentiary ruling, but the judge doesn't have discretion to ignore this court's precedent. We argued cooperative leasing tour as controlling precedent. The judge got it wrong, according to Dial, according to what this court has now said in Dial, has clarified in Dial. She did get it incorrect. She was bound. So I don't believe that discretion comes into play there. And as far as
when did you argue that?
I'm sorry, I was talking when you
When
were.
did you make that argument? Pre-trial and motion for new trial,
Yes, Your Honor. Yes.
but not at trial.
Pre-trial, we made the argument. At trial, we made the
I thought
argument.
at trial you didn't object to the introduction of this evidence.
The
correct?
judge had already excluded it, and that is record pages 25, 59 through 60. The judge excluded any of this evidence. And then it was raised again post-trial, and that's ironic there is in post-trial, when we filed it as part of our motion for new trial, Reichenbach responded and said, Judge, you've denied this twice already. Now they're telling you it wasn't preserved, it was never denied. That was the response in the response to motion for new trial. Judge, you've ruled twice. Don't do it, do it a third time, Judge, was the argument. So, but record 25, 59 through 60 is where that's preserved. I think that addresses the bullet points that I wrote down. So unless the court has any other questions on the issues, again, I would stress as far as the others, not only rely on the briefs, but also the cumulative effect of anything. And unless there's anything else, I'd Thank you for your time.
Thank you both very much. In order to leave our virtual courtroom, remember to click the leave button in the lower